come to order. Good evening. My name is Linda Jamillo. I retired as a justice of the California Court of Appeal after sitting in San Mateo Superior Court for 5 years. I congratulate you on coming this far in the competition. I know it takes a great deal of work. I think I have been judging this competition since it started in San Mateo County, which I think is 30 years. I admire the work and effort that you have put in, and will try to keep the courtroom lively for you and comfortable. I also want to acknowledge your parents who have supported you in this, your coaches, of course, who have spent hours and hours, and the teachers who may have helped you along the way. I would like to have our scorers introduce themselves and say a little sentence about your practice, please.
My name is Jennifer Scotto. I practice here in San Mateo County. I practice with my dad, Ben Scotto. We do workers' compensation and personal injury plaintiff side.
Thank you.
I'm Vince Scotto. This is about my 25th year doing this as either a scorer or as a judge. I practice in San Mateo. We handle catastrophic personal injury and workers' compensation matters. I'm a member of all the appropriate trial lawyer organizations. I've been doing this as a job for 34 years, and this is one of the fun things I get to do, because normally people don't call their lawyer to say they're having a good day. They usually call because something's wrong. But this is a fun thing to do because we really enjoy watching you and all the hard work you do with your coaches and your parents. So, go get it.
You have the unusual and fun opportunity to see a father and daughter working together. All right, can we begin, please, in the matter of the People versus Concha? Pre-trial. Would you announce yourself?
Before we start, Your Honor, may we begin with introductions?
Yes, please.
Good morning, or good evening. My name is Christian Ruano, R-U-A-N-O, and I will be presenting the pre-trial motion for the people.
Thank you.
And my fellow trial attorneys introduce themselves.
Yes.
Thank you.
Good evening, Your Honor. My name is Gabe Flynn, spelled F-L-Y-N-N, attorney for the people.
Good evening, Your Honor. My name is Bhavik Patel, spelled P-A-T-E-L, attorney for the people.
Good evening, Your Honor. My name is Justin Baptista, spelled B-A-P-T-I-S-T-A, attorney for the people. At this time, Your Honor, may our witnesses please introduce themselves?
Yes.
Thank you, Your Honor.
Good evening, Your Honor. My name is Dan Whelan, W-H-E-L-A-N, and tonight I'm Officer Robin Doherty.
Good evening, Your Honor. My name is George Agnostou, A-N-A-G-N-O-S-T-O-U, and tonight I'm Alex Weaver.
Good evening, Your Honor. My name is Sammy Fakori, F-A-K-H-O-U-R-I, and tonight I am Principal Riley McAllister.
Good evening, Your Honor. My name is Justin Weaver, W-E-A-V-E-R, and tonight I am Dr. Ricky Sanchez. This time, may our clerk please introduce himself.
Good evening, Your Honor. My name is Peter Camarado, C-O-M-A-R-O-T-O, and I'll be your clerk tonight. I'll also be giving 2-minute, 1-minute, and 30-second warnings.
May the defense please introduce, Your Honor?
Yes.
Good evening, Your Honor. My name is Allie Miller, M-I-L-L-E-R, pretrial counsel for Ray Concha. At this time, may my co-counsel please introduce themselves?
Yes.
Good evening, Your Honor. My name is Sadie Bronk, B-R-O-N-K, counsel for Ray Concha.
Good evening, Your Honor. My name is Christina Wadsworth, W-A-D-S-W-O-R-T-H, counsel for Ray Concha.
Good evening, Your Honor. My name is Pooja Katal, K-A-T-H-A-I-L, counsel for Ray Concha. At this time, may our witnesses please introduce themselves?
Yes.
Good evening, Your Honor. My name is J.D. Horsley, H-O-R-S-L-E-Y, and tonight I am Avery Perkins.
Good evening, Your Honor. My name is Annie Kim, K-I-N, and tonight I am Dr. Casey Burke.
Good evening, Your Honor. My name is Jacob Julian Kwong, Julian-Kwong, and tonight I am Dale Piper.
Good evening, Your Honor. My name is Tara Saha, S-A-H-A, and tonight I am Ray Concha. At this time, Your Honor, may our courtroom bailiff please introduce herself?
Yes.
Good evening, Your Honor. My name is Lauren Henske, Henske, and tonight I am your bailiff. May I now present the rules of the court?
Yes.
Thank you. Good evening, and welcome to the semifinals of the San Mateo County Mock Trial Tournament. There will be no food, chewing gum, or beverages with the exception of water. At this time, please silence your cell phones and refrain from talking during the trial. Please note there will be no videotaping or flash photography without permission. Thank you. Your Honor, at this time, may our unofficial timer please introduce herself.
Good evening, Your Honor. My name is Samantha Frankel Popel, FRENKEL-POPELL, and tonight I am your unofficial timer.
All right. May we begin with the pretrial motion then?
Yes, Your Honor. Once again, Your Honor, my name is Allie Miller and I represent Ray Concha. May I proceed?
Yes, thank you. And if all of you would do that, it would be a great service to the scorers. So if you would say your name again, even though you've already said it twice in the evening or 3 times in the evening, it would be helpful. Thanks. Go ahead.
The defense moves to suppress testimony from Officer Doherty about items in Ray Concha's car because the officer's search of these items violated my client's Fourth Amendment rights. Now, the Fourth Amendment states that individuals have a right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Katz v. United States, 1967, establishes a 2-pronged test to determine whether a search is unreasonable. First, has the person shown an actual subjective expectation of privacy in the object searched? And second, does society view that expectation as reasonable? Now, I'd like to start with that first prong, the subjective expectation, by looking at what Ray Concha did on the night of the search. Ray Concha parked her car in the supermarket parking lot, saw a few confrontational kids. She realized she had items in her backseat she wanted private from those kids. So she took her backpack and placed it over the items. Then, for good measure, she took her jacket and draped it over the backpack. Ms. Concha then left her car, believing that her items were covered, her windows were tinted, and that no one would see those items. Later, Officer Doherty even asserts that it appeared as if someone was trying to cover up those items. Therefore, given these facts, there can be no dispute as to the first prong. My client did have a subjective expectation of privacy.
The front windshield wasn't tinted, was it?
No, Your Honor, it is legal for a front windshield to be tinted.
So what does that do to your client's expectation of privacy?
Your Honor, it does not diminish the expectation of privacy because the only way the officer was able to see my client's items was by climbing on top of the car. And even when he did that, he asserted himself that it looked like someone was trying to cover them up. So regardless of the reasonableness, which I will address as the part of the second prong, my client certainly had a subjective expectation. Yes, Your Honor. Now, as to that second prong, whether the expectation of privacy is viewed as reasonable by society, we must look to what the officer needed to do to see my client's items. Now, Officer Doherty walked up to my client's car, and standing in the parking lot, he looked through the only cracked window. But all he could see was backpack jacket. Couldn't even tell that there were items underneath that backpack. But suspicious of my client from prior experience, Officer Doherty went to the front of the
2 minutes.
stepped on the tire of my client's SUV, hoisted himself up completely off the ground, leaned over the car so far his head was in the center of the front windshield. That was the first time that Officer Doherty saw the items in question. It was perfectly reasonable for my client to expect that items she placed in her backseat would remain private when the only way the officer was able to see them was by climbing on top of the hood of her car. In Arizona v. Hicks,
Was he on top of, was the officer on top or leaning over?
Your Honor, he had to step onto the tires, therefore he was completely on the hood and needed to lean over with his head in the center of the front, making him on top of the car. Now, in Arizona v. Hicks, 1987, the court found that in that circumstance, the officers had violated the defendant's Fourth Amendment rights because the officers had picked up the defendant's stereo to look at serial numbers on the bottom and then ran the serial numbers to discover that the stereo was indeed stolen. Now, the act of picking up a stereo is much less intrusive than the act of
1 minute.
stepping on the tire and leaning over the hood of the car. And therefore, my client's
Except that your officer didn't touch it. It wasn't more intrusive in terms of what the officer actually did, was it?
Your Honor, in neither case did the officer actually touch the evidence in question, the serial number or the items underneath the backpack. But in our case,
Wait a minute, the officer in the case picked up the stereo and turned it over, right?
yes, Your Honor, and the search was not of the stereo, that would have been fine, but in fact of the serial numbers on the bottom.
Okay, go ahead.
Have I answered Your Honor's question?
Yes.
Yes, Your Honor. Now, the act of picking up a stereo just maybe 6 inches is much less intrusive and considered by society as much less intrusive, which is the standard we need to address when considering the second prong.
Well, how do you know that? Why is that more intrusive than picking up the stereo when you're lawfully in a suspect's home?
Your Honor, the act of climbing on top of someone's car is less societally expected than someone picking up a stereo. Your Honor, I'm basing my argument on common sense. Yeah.
Okay, that's fine.
Yes, Your Honor, I don't have any case law to prove that picking up a stereo is less intrusive than climbing on a car.
Go ahead.
Yes, Your Honor. Now, therefore, my client had a subjective and reasonable expectation of privacy and Fourth Amendment protections apply. Furthermore, the plain view exception
30 seconds.
cannot apply because plain view is defined in People v. Rogers as when an officer is lawfully present and sees the items in question, but the officer needed to trespass on my client's car for private property and therefore exited a place that he was lawfully present. For these reasons, Your Honor, we ask that you grant the motion.
Okay.
Thank you.
Prosecution ready?
Yes, ma'am. Good evening, Your Honor. The defense has missing. Oh, my name is Christian Ruano, R-U-A-N-O. The defense has misinterpreted the facts. Officer Doherty never, in any instance, touched the hood of the car. He rather put his foot on the tire and leaned over the hood, such as would be as an airplane would fly over your house, or a tree branch leaning over the hood of a car.
Oh, but he was standing on the wheel.
His foot was on the wheel, such as would be like a police officer putting their foot on the hood of the tire to check the car serial number, or someone tying their shoes on the tire.
Okay.
Officer Doherty did not violate the Fourth Amendment and infringe upon Ray Conch's constitutional rights. As you heard, the defense attempted to lead you to believe that the act of Officer Doherty looking through the windshield of Ray Conch's car was improper and unconstitutional. But in reality, this is clearly false. The defense tried to further bolster their points
Why is it clearly false?
that
That standing there is unconstitutional? Looking through the center windshield.
Well, Your Honor, the defendant's car was parked on a public parking lot, and according to United States v. Dunn, there is no difference between a public parking lot and open fields. The defendant also had a diminished expectation of privacy, through which it was legal for Officer Doherty to peer through the windshield of the car.
Why does he have a diminished
Expectation of privacy. The defendant had a slightly lowered down window in the back of his car, which led to his diminished expectation of privacy, and her parking on the grocery store public parking lot diminished her expectation of privacy.
But if counsel is only arguing that it is the viewing through the center windshield that is unreasonable, does the owner of the car have a diminished sense of expectation of privacy from that untinted window?
Well, Your Honor, Officer Doherty used a legal vantage point to his advantage by peering through the windshield, but he protected Ray Conch's constitutional rights because he did not touch any part of the car, just rather the tire.
Okay, but the tires are part of the car, right?
Well, the tires,
I mean, I think we're stuck here. The tire's definitely a part of the car. So why do you distinguish between the tire and the hood of the car?
well,
He's standing on the tire wheel.
well, one of his feet were on top of the tire while the other was planted on the ground. So, the tire,
Go ahead.
his foot was on the tire to protect the defendant's Fourth Amendment rights. Rather, had he touched any other part of the car, he would have abridged this and constituted an illegal search. So by doing this, he saved the defendant's constitutional rights and did not break the Fourth Amendment.
So if his body was leaning over the hood of the car, then you would agree with the defendant?
No.
If he were leaning over and touching the hood of the car, you would agree with the defendant?
Yes, Your Honor, but Officer Doherty did not touch any part of the car, just the top.
And because he had one foot on the ground, that makes it all right?
Yes, Your Honor.
Okay, go ahead.
The prosecution respectfully requests that you deny the defense's motion. On the evening of February 22nd, Officer Doherty approached Ray Conch's car and simply looked inside from a legal vantage point. He then legally shone a flashlight through the windshield and saw inside a ledger, a roll of money, and narcotics. This was not a search since, according to Horton v. California, Officer Doherty was lawful in his presence next to the car. Even if it was a search, his actions did not abridge the defendant's Fourth Amendment rights, since Officer Doherty's looking through the windshield of the car was under the plain view exception to the warrant requirement. The facts of our case are straightforward. Officer Doherty was at his local supermarket buying groceries when he noticed the defendant's car parked in the public parking lot. In the court case United States v. Dunn, there is no difference between a public parking lot and open fields. Officer Doherty was lawfully present to where he was and had lawful access to getting around the defendant's car. The car is not part of the defendant's curtilage, and the items in question were in plain view. That is why Officer Doherty was able to see the effects without having to enter the car. Furthermore, it is irrelevant to whether Officer Doherty shone a flashlight or moved his position around the car to see the items which were in plain view, such as was found in Texas v. Brown.
But the items that the defendant is worried about are not only the items that the officer saw when he put his flashlight in the 2-inch roll down space, right?
That is true, Your Honor.
So how they're in plain view when he's climbed on top, when he's leaned on top of the car, the SUV.
They were in plain view when he looked through the window, as well as his legal vantage point that he used when he leaned over the head of the car.
Right. The window, he only saw the backpack and the jacket, right?
Yes, Your Honor.
He didn't see the roll of money, the ledger, or the pills in the baggie.
No, he did not.
And that's what the defense is arguing about. They don't care about the backpack and the jacket. So tell me, you're arguing, let me understand your argument. Your argument is that the defendant had no expectation of privacy because he was parked in a public lot, which you correctly analogized to the open field. And because he had the 2-inch window space?
Well, the defendant had a diminished expectation of privacy. No expectation of privacy is absolutely kind of irrational, but she had a diminished expectation of privacy through parking on the public parking lot and having the windows slightly cracked down.
Okay, go ahead.
In Brown, the court found plain view as an extension to whatever the prior access to an officer's access to an object may be. Our cases also inform that People v. Rogers and United States v. Copeland, as both of examples.
2 minutes.
Shining the flashlight was legal and did not infringe on the Fourth Amendment rights. Doing so did not violate the Fourth Amendment right in these cases and is in play in our case as well. Here, Officer Doherty merely used his position to see the items which were in clearly plain view. Furthermore, the use of the flashlight is proof that seen by those means it could clearly be seen by any other way, such as sunlight.
If you're leaning over and looking through the windshield of the car.
Yes, sir. If the defendant's true purpose was to hide her items, then she would have made sure she did so instead of letting them be seen in the back of the car.
Does that suggest that all defendants are completely consistently logical? hide it, I would have done a really good job. I don't know where that leaves the police.
Well, Your Honor, in this case, the circumstances are different as Officer Doherty found narcotics ledger and a roll of money. I don't think they would find this in your car.
All right, go ahead.
Additionally, car windows provide no expectation of privacy, and simply tinting them doesn't authorize someone not to look through. Officer Doherty immediately saw the effects in the back of the car to be readily incriminating. Through his extensive drug recognition training, taught him that the items in question were in fact drugs and sales paraphernalia. This further proves beyond a doubt that Officer Doherty was lawful in his presence next to the defendant's car and was not abridging the defendant's Fourth Amendment rights. Lastly, the intrusion caused by Officer Doherty, if there was any at all, was not outweighed by the defendant's diminished expectation of privacy. Likewise, there was no legitimate expectation of privacy that shielded the interior of the car, which could have been seen by any member of the general public. Doherty
Who climbs on the top of the car?
leaned over.
Okay, who
from
leaned over
from
on the
a-
top of the car, but not, we're not talking about a tall person such as yourself leaning over the car. We're talking about perhaps a tall person, or a small statured person who needs to stand on the wheel well.
Well, Your Honor, there is no difference between, as if I were leaning over the hood of the car, who would not need a tire to see over the car. There's no real difference between that.
Because?
Because that would be subjected to a shorter person or a taller person.
The difference that I see is that the tire belongs to the defendant. It's his car. Does he have a reasonable expectation that people aren't going to be standing on top of the wheels to look into his car?
Well, Your Honor, the tire is meant for such purposes as going on much rougher surfaces than the bottom of someone's shoe. And would be
That's good.
and would be expected to handle much heavier things than some person.
All right, go ahead.
Officer Doherty's position partly over the hood of the car was still considered a legal vantage point that allowed Officer Doherty to clearly see the interior of the car. The prosecution respectfully requests that you deny the defense's motion, as Officer Doherty's actions did not abridge the defendant's Fourth Amendment rights.
30 seconds.
And did not abridge the Fourth Amendment rights and violate the constitutionality of the search. Thank you.
Thank you. You want to?
Yes, Your Honor. Once again, Your Honor, my name is Allie Miller. May I proceed?
Yes.
Opposing counsel discussed the diminished expectation of privacy of my client by pointing to the cracked window. However, the cracked window is irrelevant to the assessment of the items underneath the backpack, only if the defense were disputing the backpack or the jacket, which were visible through that cracked window. Opposing counsel also stated that my client's expectation of privacy was not reasonable, and also that it was in plain view. Two separate tests, both addressed in the same manner by opposing counsel, that Officer Doherty was lawfully present and is expected to be on the tire of that car. However, as Your Honor pointed out, the tire is a part of the car and is my client's private property and therefore is protected under Fourth Amendment. Now, opposing counsel stated that the officer had 1 foot on the ground and 1 foot on the tire. That could still happen and the defendant could have Fourth Amendment protections.
1 minute.
However, it clearly states in the fact situation that to get a clearer vantage point, Doherty stepped on the front passenger side tire and lifted Doherty's own body partially over the hood of the car. Nowhere does it say that the officer kept 1 foot on the ground, and it doesn't make sense because he wouldn't be able to hoist himself up if he still had 1 foot on the ground. Therefore, the officer did